Good morning. My name is Whitney Untiedt, and I am a partner and pro bono director at Akerman, housed in our Miami office. And it is my pleasure today to be here to moderate this panel of esteemed leaders and colleagues from across the state of Florida. We were tasked with the subject of juvenile sentencing, which we as lawyers have decided to construe liberally. So we're not just going to be talking about juvenile sentencing post-adjudication, but we're also going to be talking about decisions that are made about outcomes in cases at three separate areas. Number one, at intake. Number two, at juvenile detention decision-making. And then number three, at adjudication. But before we get into the conversation, I am excited to introduce to you our panelists today. To my far right, your left, is Brian Berkowitz, who serves as the General Counsel for the Department of Juvenile Justice, overseeing all of the lawyers who provide legal services to the department and advise policymakers on issues relating to juvenile justice. They also do, if you're not already intimately familiar with all of the data collection that DJJ does, Brian oversees a lot of that. It is excellent, probably the best data collection module in the entire country. Directly to my right is the Honorable Senator Perry E. Thurston Jr., who serves in the Florida Senate, serving District 33, which is part of Broward County. He's a leading proponent for restoration of civil rights efforts and was first elected as a state representative to House District 93 back in 2006 and has been serving his districts with distinction since then. Moving over to my left side, directly to my left is the Honorable R.J. Larizza. Please don't call him Ralph. He is the elected state attorney for the 7th Judicial Circuit and gets to live in fun places like Daytona Beach or St. Augustine, Florida. His election to the position followed a career as a prosecutor and in private practice before going to law school. Prosecutor Larizza served the Florida Department of Corrections, working directly with offenders for 13 years. To his left is the Honorable Julianne Holt, the elected public defender for the 13th Circuit right here in Tampa. She served in that position since 1993 and has practiced in the area since she graduated from law school in 1980. Ms. Holt has received numerous awards for her commitment to criminal justice and her commitment to public service and will shortly be inducted into the Hillsborough County Women's Hall of Fame. We've got an amazing panel of fabulous leaders. Thank you. Who have spent their entire careers looking at these issues from four very distinct but interrelated perspectives. I want to start our conversation with pre-petition considerations. Our panel is very interested in talking about diversion and civil citation and how it's worked in Florida, particularly since civil citation has been adopted and incorporated into our Florida statutes. So I'd like to start with Mr. Berkowitz and DJJ information about the civil citation process and how that has worked. Can you give us an overview?
Certainly. It's worked very well. Actually, we also have in the audience with us is Theda Roberts, who's kind of guided and developed and pushed civil citation around the state for the department for the last several years, and so she's going to catch me if I say anything that's wrong. But civil citation's been around for quite some time, since the early 90s, but was only used in a few jurisdictions, not very frequently. So with the incoming administration from Secretary Walters from Miami, who really utilized civil citation down there when she worked for the county, we have truly grown. And the latest legislation basically said all the counties and circuits should have civil citation. It's not mandatory. There's been some efforts to make it mandatory. The department hasn't taken a position on that, but we think it's really good. The best part of it is that the numbers of kids that have gone through the civil citation program, only 4% recidivate. So it's been very successful. And we've kind of always known that there are a lot of kids out there that commit an offense, and if they don't get caught and nothing happens to them, most of them will not commit another offense. Then there's those who get caught. Nothing serious happens, and they still won't commit an offense. And that's who this is geared to. So we're not using a lot of department resources on kids that may not be coming back into the system. But the good thing is, if they get a civil citation, it's not that nothing happens. They get an assessment, they get evaluated, what are the issues that might have caused this, and they get services available to treat that. They do some community service hours. They have no record. The civil citation referral is not considered a referral to the department. We keep track of it, but on our prevention side, it's not available to the public, and so the youth has no record for that. We think it's just been real successful, and encourage all the counties and circuits to use it.
And Senator Thurston, from your perspective, serving up in Tallahassee, what are the conversations happening amongst legislators and lawmakers on the topic of juvenile civil citation and diversion?
Thank you, and I want to thank you, Whitney, for moderating this panel, and it's good for me to be here next to such a distinguished panelist. With regards to the conversation in Tallahassee, I first want to say that in Broward County, we adopted the process right away, and as has been represented, it works, and it's working very well. We do have a conversation in Tallahassee about the fact that it's not uniform across the state. The fact is, we think that every county should be utilizing it, and I know that clearly Broward County, Dade County, we're not like Leon County, Putnam County, but I think that children should have an opportunity, and sometimes they're a mistake, but if we can keep them out of the system, and I think that's one of the main things that Mr. Berkowitz commented on, the fact is that they're keeping a record of it, but they're not in the system as long as they do what they're supposed to do and correct whatever the problem is. So our discussion is, how do we make sure that the opportunity is there across the state for youth in all the jurisdictions, such that we can eliminate them from the system and we can focus on the youth that we really need to put our resources behind.
So I'd like to turn to this side of the table, and I want to caution everyone that we did place a prosecutor right next to a defender, and we have a gentleman's agreement that we will not be coming to fisticuffs this morning.
I have no doubt about that.
But I'd be interested to hear the reports from your jurisdictions, from the FPAA, from the FPDA. How is civil citation working? Is it working as it's supposed to? Is it working differently, as we've heard perhaps from jurisdiction to jurisdiction? And how are you seeing it from your perspectives as defenders and prosecutors?
Well, from the standpoint of the Public Defender Association as a whole, obviously what we recognize is that the different jurisdictions are implementing different types of programs, number one, and then number two, the statute presently allows for 3 opportunities, and in some jurisdictions, you're still limited to just the very first time that you come in contact with the system. That happens to be Hillsborough County. Hillsborough County, although we've had a program since 2004, 2005, it started out school-based because we'd had 2,500 referrals out of the school system. So the school system is who created a civil citation program. Since that time, we now have what is a county-wide agreement that is really driven primarily by our chief judge and then by law enforcement. So right now we allow civil citation for the first offense only, and we allow it with 13 misdemeanor crimes being exempted. And one of those crimes happened to have been possession of marijuana, which, as you can imagine, about 8 months ago, we finally entered into agreement to allow not a civil citation, but a delinquent act citation. We had to create a separate program to allow possession of marijuana, and as you can imagine, that is one of the areas where we have the highest number of children coming in. Hillsborough County's program requires an assessment, an education component, and then a service component. So we've certainly, as the public defender here in our jurisdiction, we've taken the position that with those 3 criteria, we believe that it should be expanded to all misdemeanor offenses, and we also believe it should be expanded to include what the legislative intent was, which was 3 opportunities. That right now is in discussions. The biggest pushback, frankly, that we get here in our jurisdiction is from law enforcement. The entire program is discretionary. It's not mandatory. So as you can imagine, we spend many, meetings and discussions talking about minority overrepresentation as it relates to arrest versus a civil citation. But both of our major law enforcement agencies have supervisors that oversee when a child is not afforded the opportunity of taking a civil citation. That supervisor has to sign off on that. The biggest impediment here in Hillsborough County is primarily usually getting a parent to come to the location where the child is to sign off on the civil citation and what that process will be. So we're trying to create this friendly door concept at our Juvenile Assessment Center for the future, which will allow law enforcement to take the child, not detained at the center, but at least as a friendly door concept. And that's where we're headed.
And what about from your perspective?
Good morning. How y'all doing today? It's happy to be here. I can tell you about my experience in the Seventh Circuit first, and then kind of extrapolate that a little bit to the statewide. And I'll start with what one of my law professors told me, one of my favorite ones. The answer to every question is yes and no. And when you ask, is it working? My answer is yes and no. When kids get in the program, it's working. When I started looking at the civil citation program in the Seventh Circuit, I noticed some counties were doing more than others. And when I say more, I mean the percentage of eligible kids who were actually getting the opportunity. And so I met with DJJ, and I started meeting with law enforcement. Volusia County was having the most trouble. And one of the problems was that I had no idea was DJJ was having an issue with restitution about collecting it. They needed help in that county because no one was collecting it. And so kids who would be eligible otherwise for the program weren't getting it because of the restitution issue. So I said, guess what? The state attorney's office will collect the restitution and we'll distribute it so that we can get these kids in there. My point there is that this program requires communication between all the players. One of the other problems was law enforcement, not that they were resistant to it, but anybody who's been involved in law enforcement, and as a probation officer, I was considered a quasi-law enforcement officer. Change is not always welcome. You got to explain things to folks. And you got to explain it to them in a way that they don't feel like you're trying to do their job for them. And secondly, that you will help them accomplish it and help them understand that it's a good thing. And in Volusia County, what I did was I entered into a memorandum of understanding there were 15 law enforcement agencies in Volusia County. 15. And we got every one of them to sign the MOU. Now, I had to be a little flexible because some of them wanted animal cruelty to be case by case. I was big on, I didn't think domestic violence was appropriate, but then I listened to some of the other folks and I said, we can make it case by case because maybe it's two brothers or a brother and sister who get into it. It's not some kid who's attacking their mother or father, which might be more serious and more difficult to deal with. So flexibility is very important, not just in civil citations, but in the juvenile system and in the criminal justice system, I believe. So but the other counties were doing better percentage-wise. And as state attorney, I'm not going to walk in there and say, hey, you need to change what you're doing, especially if it's working right. Sometimes leadership means letting somebody else lead. And what I believe me and the colleagues, all of my colleagues in all 20 circuits, all 20 state attorneys understand that. We want to help civil citations be successful. And I think that we will continue to work with the different jurisdictions, different counties for their specific and unique needs and do a little diplomacy to help folks understand that these are misdemeanor offenses. I think we might have maybe two or three that are either exempt or case by case. And so far, so good. I'll knock on wood a little bit there. And hopefully we'll continue to be successful in the Seventh Circuit and improve the numbers, the percentage of eligible kids who are participating.
What I have heard, I think, from each of our panelists is that there has been an uneven implementation of the program across states. And in the jurisdictions where it has been expanded, I don't know, Brian, if you have data on circuit by circuit recidivism rates.
Not here, but
Okay.
and I'll put in my plug right now, because that's one thing that DJJ has recognized around the country as really the leader in data collection, and not just data collection, but data use. We make so many decisions based on the information that we've collected. We have a dashboard that's online. You go to DJJ, and I think we've got a slide with the address and everything on it, but just go to DJJ and find the dashboard. And if you can't find data you're looking for on that, it probably doesn't exist, but you can also contact our research and data people, and they can provide it at circuit level, at county level. It's an amazing source.
Of the 38% who were eligible who didn't get civil citation, what their recidivism rate was? I mean, I'm a big proponent of the civil citation. I'm hoping the number shows what I want it to show, but that would help tell.
We'll have it, because those would be kids that would go into probation and or commitment, probably probation, if they did not get
They're
the.
lumped in with the others who
Yeah,
aren't.
yeah.
That would just be interesting.
I mean, I don't know if we have that divided out or if we could, but if it can be done, we've probably done it.
And I'd just like to add, sometimes what folks don't understand is sometimes the kids, they have to buy into it. Sometimes that the rejection is not that they were eligible and weren't offered it. Sometimes they didn't accept it, and sometimes the victim objection is a tough one too. If a victim objects, the question is, do you override the victim and say, no, they're going through the program even though the victim doesn't want them to, or do you try to work and convince the victim? And we've settled in the Seventh Circuit on ultimately we can override the victim, but typically we give them great weight. And it's rare, but at times we do have that possibility. So the rejection sometimes is not a rejection from law enforcement or from the institutions involved. Sometimes it involves the kid or the parents themselves that just don't want to participate.
Whitney, I think that we cannot underestimate the fact that when we have cooperation, how far we can go to making the system actually work. In Broward County, where I'm from, we have a no-nonsense state attorney who's been there for a long time, Michael Sachs. We also have a sheriff who's pretty no-nonsense. And they've actually come together. We meet with the community. They met with the community, the Urban League, the NAACP, and they talked about, what would be the benefit of this civil citation program. And it's working tremendously. And the 3 opportunities that the public defender spoke about, we're doing that. It's working. We're trying to get other communities to come on and participate as well. But I think one of the overriding themes of this conference has been cooperating and working together. It's easier to work together to accomplish some of these things clearly than to get another legislative fix in Tallahassee. I don't know what those guys be thinking about, but if we can do it within our own communities and take what we have and make it work, I think it'll certainly be beneficial for our youth.
And then,
One
Ms.
of-
if I can, I want to give you the last word on this, but I also want, as we're moving forward in our conversation, if you could, once you talk about civil citations, Ms. Holt, if you could then sort of lead us into pretrial detention, because at the same time that we're having these very collaborative conversations about the positive outcomes in civil citations, we are also seeing movement towards mandatory pretrial detention and the rise up of the prolific juvenile offender status.
I think one of the things you've heard everybody say here about is collaboration and communication, which is one of the things that we do here with our state attorney that just recently was elected. He actually he has somebody that looks at all the first-time offenders coming into the system, and if they did not receive a civil citation, they reach out to our office, and then we try to communicate with that child and their family to find out why they did not get a civil citation. Sometimes it's they wouldn't admit they were guilty at the scene, or they wouldn't express remorse. And so what we do is we find another pre-filing diversion program that we can place the child into that has the same components. And what we find, obviously, is that if you're waiting on a parent sometimes to agree to this process, that's really an impediment a lot of times here in Hillsborough County because we just can't get the parent to get involved. So we actually have provided law enforcement a contact number in our office where they can call us, and then we'll reach out to a guardian or we'll reach out to the child directly and say, hey, here's what the benefits of everything are to you. So you really have to go that extra step. And people always tell me, you know, you're not funded for that. And I go, yes, I know, but guess what? It's reduced my caseload tremendously because we've gone from having 7,000 juvenile cases pending at one time to about now 2,900 coming into the system. So it's really, really different. And one of the things that when we were getting ready for this panel that we kind of thought we might want to talk about a little bit and just get some people's feelings was effective in October of 2017 was a new detention status called the prolific juvenile offender. And for those of you that do defense work and state attorney work, you know what we're talking about. But when that was created, it was, for me, it was, again, one of those moments where people had seen the rash of auto thefts that were happening in Pinellas County. There had been a horrific wreck that had occurred where there were some deaths that had happened. And all of a sudden, we started talking about these prolific juvenile offenders. And to me, what was bothersome about it was we were creating another stamp on a young child, and we were going to give them now this scarlet stamp on them. And it really bothered the Public Defender Association as a whole, and it really bothered me in particularly because, you know, after you've been doing this for 20 some odd years and you see all these HVFO, HFO, MinMan, all these things that are developing that now 25 years later we're having to relook at what have we done in our criminal justice system and our juvenile justice system. You know, here we go again. And for Hillsborough County, just so you know what it meant for Hillsborough County, we created this entire detention process for the maximum number of children that have been designated by DJJ for consideration was 13 in Hillsborough County, 13. Of those 13, probably 3 have actually been found by the judge to be a prolific juvenile offender. What it has done, obviously, is it has increased how long you can keep a child in detention, secure, non-secure. There's different ways of doing it. But here's the downside for us. What are the services that are being provided to a child while they're in detention? And what are the services that are being provided to the child while they're waiting for their commitment program? And are you going to once again put us in a position where a child is lingering, as we just had one child stay for 4 months in detention awaiting placement into a program? And you know, as an elected public defender, your options become you try to move the court to try and change the sentence in some way, or do you decide that you want to take on the Department of Juvenile Justice, who just doesn't have the funding or the beds in order to have the children placed timely into a program? Do you go to your county? And you know what that sometimes means is you file a lawsuit, and if you ever have filed a lawsuit against a big agency, you know that's probably not one of the most popular things. Everybody in Tallahassee would be talking to you about it. And so for me, it's another example, though, of how we just won't treat what the real problem is. We should have focused on whoever these children were. We all have the ability to go to DJJ, whether it's law enforcement or everyone else, and talk to GJJ and say, okay, who are the kids? And then you go to the court and you say, hey, I want this child to have a curfew. And by the way, in Hillsborough County, what we do for kids that we put on detention that are considered high risk, law enforcement goes to their house every night to see if they're home. That's just as easy as putting that label of prolific juvenile offender, in my humble opinion, that is.
So I want to turn to you, Senator Thurston, and learn if you can share about some of the conversations in Tallahassee during debate and leading up to the passage of the prolific juvenile offender language into the statute.
Well, I do want to tell you that I probably wouldn't be the best person to talk about the prolific juvenile offender, because if you look at the vote on this particular legislation, I was probably the only person who voted against it. But that being said, I voted against it for a number of reasons, many of which Ms. Holt just outlined. During our previous session, there was some discussion about the late 80s when we had the British tourist murder and the German tourist murder and what the results were in the legislature. And we as a body tend to overreact to certain things. And what we do is we come up with these long-term statewide statutory fixes as opposed to what Ms. Holt said about finding out who are these kids who are breaking in these cars, who going to their homes and monitoring them. So what we're looking at short-term trends because we've had the situation in Broward where we had a extended amount of break-in and car thefts, but we didn't create a whole statute to deal with it. And I think that as legislators, until we can get individuals to having discussions like the ones that we're having right now, and that's why I think it's so great that the bar is doing this, is that we're forcing people to address the issue. Let's see what did all of the money that we put into this prolific juvenile offenders, where is it resulting? What are we getting from it? Are we getting kids who are languishing in detention while we determine that only 3 of them really meet the qualifications? And so we have to be willing to have that discussion. One of the things that Chief Justice Kennedy said earlier as we kicked off this session, he said, what works? Well, the truth of the matter is that the people at this table and in this conference, you know what works. You know whether this is the answer. We have the statistics from DJJ to tell you what works, what isn't working, and we can make the changes. But in the bubble of Tallahassee, Whitney, what you asked me, what are the discussions? We still have a mentality in Tallahassee that we want to be tough on crime. We may say we would prefer to be hard on crime, but when it comes right down to that final vote, nobody wants to get that flyer. And I know you're getting a lot of direct mail from candidates right now, but nobody want to get that flyer that he voted to this guy and he was released and look what he did. But by doing that, we're pumping a lot of money into the wrong side. And if we could look at doing the right thing and have the individuals who are here, who knows what the right thing is, but they won't do it when it comes to Tallahassee. And that's the problem. And the last problem is we don't have enough representation from lawyers like you all who actually know what's going on in the system. We have individuals who've never been in a criminal courtroom in their lives making decisions about what they think is the right thing.
Mr. Larizza, what's your perspective? What are you seeing related to the PJO status in your own circuit, and what are you seeing sort of systemically when you're talking with other prosecutors?
Well, I think it's important to understand why the reason behind the law. You know, juveniles can be detained, whether, you know, at home detention or in a juvenile detention facility for 21 days typically. It's not like adult system where, you know, some serious crimes, or if they violate their bond and commit a new crime, their bond can be revoked and they can be put back in jail. And I think the reason or the motivation was, if kids are committing new crimes, if they're posing a danger, let's find a way to monitor them and try to reduce that danger and enhance public safety. Now, you could say that the prolific juvenile offender is a label, and you know what it is. I mean, you're labeling, you're saying this kid meets this criteria. For me, the way I look at it is, what we're looking at is this kid a risk? Did they do something that says that they need to be monitored more than just to be released into the community with the supervision of their parents only? And sometimes that's a good thing. Now, I'll tell you, I've been in juvenile detention facilities. I've walked in them. I have been in youth academies where you have high risk and maximum risk kids. I see it, and I'm going to tell you, it's not a good place. Kids don't learn good things in detention, and they don't learn life skills typically, or it's difficult when they get those serious commitments. But the reality is that at times, when you have a kid that might get charged with a crime and then commit another one, or somehow not follow whatever their pretrial release conditions are, we're trying to put some accountability in. Get rid of the label if you want. You don't have to label that. You can just basically say if A, B, and C occurs, then this is grounds for additional detention. And get rid of the label. Sometimes I think we love labels, we love categories, and then we complain about them after we create them. So we could get rid of the label and just have a system or a process where we could evaluate whether this kid needs to have either home detention, electronic monitoring, or perhaps even detention in a detention facility.
Does that process not exist through the DJJ risk assessment instrument and the individualized determinations that judges make at detention hearings and detention reviews?
I don't think so, not totally, because I think we're talking about kids who've already had the risk assessment and they've already either done their 21 days or been found not to score detention, and they might not score it again based on, because they may not have committed a new crime, they may have violated something else. I think the focus is on what do they do once they've been charged, once they've been released, and is their behavior rise to a level? And it needs to be, it doesn't need to be a low level, it needs to be something that people can say is reasonable, would justify some form of enhanced supervision.
Ms. Howard?
I just have a question with DJJ. Of your statistics of the 222 PJOs to date, what is the racial breakdown?
We'll have it. It'll be on the dashboard, but I don't have that.
I know, Whitney, one of the things that we have, a lot of our judges are starting to do is if they look at the risk assessment instrument from the Jack Center, what they'll do is they'll put the child, they'll release them back to the home, but they'll put some type of electronic monitoring. And they are using curfews much more, and they are also using really law enforcement. And they're suggesting with the state attorney communicating with law enforcement, this is a child that we think that you should monitor more regularly. And frankly, most of the times it is kids that are involved in one of two things, and that is either burglaries or the theft of cars. So you can see that there's a focus on that part of life. Our detention center, we obviously have a concern when we look at the demographics of our detention center here locally, which is why the services and the lack of services has become more important. And we recently met with our new person here in Hillsborough County, and as soon as we told them, hey, these kids are going to be sitting here, they're not going to be doing anything, that's never good, they had to have reached out to someone, because now they're starting to add additional services here in our detention center, which is a good thing. We at least look at it as a good thing. And we've also talked to the school system that we don't want the kids there learning off the computer. We don't want the virtual learning environment. We would like interactive teaching at the detention center. And so we do surprise visits once in a while just to see how things are going.
And to follow up with what you said, making a recommendation to law enforcement or making contact, whether it's the prosecutor or the judge or DJJ that makes contact with the school system to suggest that there may be some extra need for this child, can that be done regardless of what the risk assessment instrument says? And is it being done even if the child is qualified only for straight release?
Number one, yes, it can be done. And number two, I think that at this point, what we do when law enforcement brings to our attention certain concerns they have, we just say to them, you just let us know who it is and let us know what the monitoring is going on, because for us, we want to explain to the family why this is happening so that the parents are as aware of why this law enforcement officer is knocking on the door at different hours. And, we'll get a complaint every once in a while. They knocked on my door at 2 o'clock in the morning. I mean, we'll get those complaints, and what we say is, we understand that that's not good. We've learned that perhaps we should tell law enforcement when we believe there might be some mental health underlying concerns so that they understand that perhaps 2 o'clock in the morning is not a good time to do that. So that's why we always come back to the communication piece of it. But, we couldn't do this 10 years ago with the kind of caseload that we have. We are finally in a position here in Hillsborough County where we literally can almost do individualized case plans for people that really address the specific concerns of the youth and the family.
And Brian, I know that you brought some statistics, I think, on where we are. It may be your first slide in terms of caseloads and referrals to the, there we go.
Just the total things that are down. I mean, for some reason, crime has been down pretty much nationwide for the last several years, and Florida's at or above the national average. So these numbers, reductions in all offenses and felonies and misdemeanors, coincide with an actual increase in the number of youth that are in those populations. So the offenses are going down while the youth population is going up. And our criminal justice PhDs are working on trying to figure out why and if it's going to end. And we keep getting informed that we're approaching rock bottom, but it somehow still keeps dropping. So we're working on that. Part of that has led over the last 11 years to the reduction. And I know we're talking about crowds in the detention center and the waits that youth have had to get placed. Is when I first joined the department, we put to bed about 9,000 kids a night, a couple of thousand in detention and 7,000 residential. And over the last 8 years, we've reduced residential now to slightly over 2,000 beds, and detention has a usual population of around 1,000 or so. And there have been some changes that have driven those numbers up, but fortunately not as significantly as we thought they would. And we are looking at adding more beds. The waiting list is something that we really can't tolerate, but we add beds. It's a long process. We get the funding from the legislature, then we have to put out bids for the programs and then develop the programs. But we've got a lot of beds coming online after the first of the year with some new programs. We re-engineer our programs so that when there's a blockage at one point, sometimes it's mental health girls has been a big issue. They've been waiting for a long time. And so we'll clear out some beds, shift them over, and make more beds available to try and move that waiting list along. And the waiting time is slowly going down. So we're working on that.
So I think that's a great segue into the final topic that we wanted to cover, which was juvenile commitment, juvenile probation determinations at the dispositional phase. And in following up, Brian, on what you were just talking about and the need for more commitment options that are more tailored to the individual needs of the people, the children that are coming into our systems, I think that really goes along with one of our overriding themes of this particular panel. Beyond communication and collaboration, it's really that individualized response to the particular needs of the juveniles that are coming into contact with the system, whether that individualized determination is one that's being made at the civil citation level, at the detention level on an individualized basis, and then here at the commitment level on an individualized basis. I'd like to talk with our on-the-ground stakeholders first, Ms. Holt and Mr. Larizza, about your experiences and what you're seeing from your lawyers and the systems in your particular areas related to our graduated sanctions model that we see up on the board and the way that your offices are approaching juvenile disposition.
Well, one thing I'd like to say to make sure I get this in while we have time is that I think from talking to our prosecutors, your prosecutors, that one of the main problems or a concern is probation and then commitment, then you've got your non-secure, then you have your high risk and your maximum risk. Most of the kids that get involved in the criminal justice system they get in, they get out. I think there's a smaller number of kids who reoffend. And what happens is they reoffend, then they go from civil citations, they might get 3 bites at the apple. Then they go to probation, they might get 2 or 3 bites at that apple. Then they go to a moderate, non-secure commitment. Then they go from that to a high risk and then maximum risk. I'm going to tell you, the high risk and the maximum risk, we've got the Hastings Youth Academy in the Seventh Circuit. I've been there. I went in there and talked to those kids, and I'll tell you, they didn't really want to hear anything from me. I mean, they are, you know, that environment, and I want to applaud DJJ and tell them, I want you to understand how difficult it is. These might be kids, but they are kids that have been through this system to a point where they've got a lengthy history, and these kids can be brutal. We prosecute kids for attempted murders in these facilities, sex offenses, so they are not, those are the kind of places I think is a last resort for kids. I'd like to see the moderate risk programs expanded. You got 4 to 6 months in those programs, and it's not enough time. And perhaps maybe you could even work it where you don't have to adjudicate them in the moderate risk, or don't have to adjudicate them to put them on probation. I don't know if that's possible or not, but my point here is that let's get these kids once they get into high risk and maximum risk, the likelihood that you're going to be able to reach them and help them see the light, so to speak, and get out of this cycle of criminal behavior and despair and lack of hope and just, you know, disrespect for the system. Let's try to expand the moderate where they might need to get out of their homes. Maybe there's an issue in the home. It might be the neighborhood. It just might be their mentality. And maybe if we get them into a moderate program and we can expand the time frame, that it would be beneficial. DJJ struggling because direct files are down. Guess what? Where are those kids going? They got to go somewhere. They're going into commitment programs, and those commitment programs are getting overwhelmed. Let's expand the moderate program so that we can try to get some programs to reach these kids, and hopefully see that we can turn some of them around.
So I'm going to try to be a little bit broad at this point on this, and I think what Hillsborough County does well is that we have all committed to that you've got to have the intervention, you've got to have the education, you've got to have then the treatment services that are necessary, especially the therapeutic services, and really trying to find good community partners that will assist us in trying to really walk these children through the lives that they're finding themselves in. A few months ago, I went ahead and did a kind of like, I went into the detention system with not anybody from my office, but someone who has been involved with youth for a significant period of time. He went in there and he talked to a good number of kids that were in there. And he asked them, number one, why are you there? And he had to explain to him who he was, and he had to explain to him he didn't belong to the court, he didn't belong to the public defender, he didn't belong to the state attorney. And some of them were resistant to talk, but once they did talk, it all came down to the same thing that I think that we all probably know, and that is they would like to have a place where they can live, where they don't have firearms going off at night, so they'd like a nice, safe community. They would actually literally like to have an opportunity to have some type of employment opportunities. And they would like an opportunity to have something to do after school other than just hang out wherever they hang out. And you know, it sounds pretty easy, but when we asked them, well, why don't you have a job? Then you figure out the challenges they have. Well, why don't you just stay at school, or why don't you go to an after-school program? Usually we all know what it is, it's the economics of it. But what we did discover was that they also were looking for someone who could be a positive role model in their life. And so one of the things that is interesting is both myself as the public defender and my state attorney here, we've both discovered that we think that it's a good idea to try and partner up with good folks that we already know that are in the community and create, whether it's a life coach or a mentor or something for these children. And everybody wants to do it for the low risk. Everybody wants the low risk, the person who I've just met for the first time in the system. We've chosen to go the different path. We're choosing to go with those children that we all are seeing perhaps as serious offenses, as well as potentially very much at risk. And we've decided to go down that path. Now, my state attorney has done it through big brothers, big sisters, and that's what we're doing. We all agree on who the child is. We match up a mentor for the person, and then we take off with that. And we've created the list, and it's, initially it's only going to be a list of about 20 because we want to see how it works. From our standpoint, what we've done is we've reached out to the churches as well as to community activists that exist here, and we've asked them to take on a child and be their coach, and we've asked them to do it from the standpoint of almost as a substitute or surrogate type of parent. And what we've also asked them to do is engage the family in why we're doing this. And so you've got two offices that are trying to really focus in on kids that really need that additional support system. We're also really, really lucky here that we have very strong guardian ad litems. And we have very strong people that are interested in our system, and they're interested in taking on a child. We work with Rosemary and Sandy as it relates to our juvenile direct file children, and we just entered into an agreement with Argosy University to actually have, while the child is sitting in the county jail awaiting the resolution of their case, they're going to actually have somebody that's going to come in and not only do the assessment for us, but they're going to actually do the cognitive behavioral therapy. So that when we come back to the state attorney who's made the decision to direct file, we will have something to tell them about that child who's now been designated as an adult for prosecution purposes, and try to shift back these kids into the juvenile system so that we can remove them from that adult system, because as Mr. Campbell said earlier, once they're adjudicated as an adult by the court, that's the end for them, and there's no other opportunity. So I again will always come back to DJJ services. They need sex offender services, more expanded. They need more expanded drug treatment. There's no doubt about it. The mental health issue here in Hillsborough County, we have 180 kids that have already been found incompetent to proceed with absolutely no services available in our community. We're creating a mental health court to deal specifically with those juveniles, and we're asking all the partners to come to the table, not only with ideas, but with money and with a plan on how to do this intervention and these services. So for me, I think a community has to do an awful lot of self-reflection, figure out what it is you really want to spend your money on. We're fortunate that we have a great Board of County Commission here who has designated about almost $3.5 million just for mental health. They're going to create for us an actual safe haven type of residence. We're going to really take the system, the dependency system, the foster care system, and the delinquency system, fold them all together for the purposes of intervention, treatment, and making sure that our families get healthy and whole again. So we're looking at this really from a public health approach here in Hillsborough County.
Senator Thurston, let's talk about money. If we all are here at the Criminal Justice Summit presented by the Florida Bar to think through ways to divert people from criminal activity, to divert people from prisons, to divert juveniles from increasingly high-level facilities, that means that the state is going to have to fund community interventions, is going to have to fund educational opportunities, both in secure settings and in the community, is going to have to fund therapeutic interventions and treatments for children who are system involved, whose families cannot afford these services themselves, is going to have to be able to fund the potential expansion of secure beds and facilities designed to actually treat children before they end up in high-risk facilities. What is the willpower in Tallahassee to do that?
I think that Ms. Holt is actually correct in terms of reaching the children and mentoring them before they reach the maximum facilities that was referenced earlier. And I think that in the communities, we certainly see volunteers who are doing that. But for every 20 youth that she's talking about, there are 200 more youth that are out there who are not getting that type of mentorship. And that's where the state comes in. When we talk about intervention and education and services, including mental health. You know, when we had the shooting at Parkland, we had a mental health component that we wanted to interject. Some of us were also saying, well, we've been asking for mental health for kids who in their community have shootings every day. Every day. But they don't get the mental health that we know that they need if they're going home to that, coming back every day. So it comes down to what are the priorities of the state? And you say, well, you're Senator Thurston, maybe you should look at those priorities. Well, you have an agenda. You know, it's so amazing that some people ask, well, why aren't these bills addressing this being filed before? Well, the truth of the matter is that they have been filed. And the leadership in Tallahassee hasn't seen fit to put them on the agenda. You can file a bill, and I was talking to Carrie today about this. There have been so many great suggestions that we've made here. And all it takes is for us to push it and to get the leadership to say, well, put this on the agenda. That's the problem. Your budget is a reflection of your priorities. And if your priorities are not your children, then you're not fully funding it. You're not making sure that they get the needs. When the other panelists talked about, is the juvenile justice system working or is it broken? These same children that are in these maximum facilities, what happened when they were in dependency? That's where it started at. Would you put the money there to help the children so that they won't get to this level? Or is that not your priorities? You know, sometimes we can't have tax cuts if we don't want to help the least of the community. Maybe we prefer to lock them up. But the fact of the matter is the finances are there. You know, I often ask when we say we have a surplus. Well, how do you have a surplus when you're not taking care of your basic needs? The bills are being filed. The requests are there. It's not being placed on the agenda to be addressed. That's why we have situations like the other gentleman in the previous panel says, well, we're going to go to a citizens initiative for direct file. We're going to take it to the citizens and let them vote. Why is that? Why is everything required to go to a citizens initiative? Because we're not doing it what the people are requesting in Tallahassee. And there's a reason for that. It's the tough on crime mentality. We're going to talk about we want to raise the threshold for grand theft, but when it gets right down to the bottom line to take that vote, we're going to lump it with a lot of other bills, and then it's going to fail. If you're serious, you put it on the agenda at the beginning of the session, you pass it, and then we move forward and we make other corrections. See, that's why this meeting is so important, because you're coming with ideas that we should have been done, that we could do. You know, there was said in the last, yesterday that, well, this is not going to change overnight. Well, it could. It could if the willpower was there. If you wanted to change it where we decouple driver's license for criminal offenses, that could happen the first week of the session. We could put more money into areas. We could do that. But that's not the priority of the legislature, and that's why it's not getting done. So, my last point, because I know I'm not going to get to speak again, is when you get all of those flyers in your mail, those flyers about electing me to this Senate or this House position, then these same questions that we're asking today, these same suggestions that you've got, just ask that question. Well, can we make this simple change to put more money into funding dependency programs? Can we give children mental health support? Can we do any of these things? It's not that complicated, but it's not the priority of this legislature, and it has not been. And that's why when we have a catastrophe like Marjorie Stoneman Douglas, we don't have to invent bills. We just pull the one out that you were not going to put on the agenda before, and now we'll hear it. And that's where it's at, is what are the priorities of your legislature that you vote for?
So, Mr. Berkowitz, let's live in a little bit of a fantasy land for a moment. And looking 2 years down the road, say that the stakeholders here in this room have been able to push the needle forward a little bit in Tallahassee and have been able to get the legislature and the governor to approve increased funding for the Department of Juvenile Justice. From your perspective, can you speak to what the department sees as priorities. Are you allowed to speak to what the department sees as priorities?
I would be very wary to do so. Certainly some of the initiatives that we've undertaken in the past, some of the challenges the department has, clearly the correct number of beds. If we have a sufficient number, and we've asked the legislature for additional beds, and they've been very good about supporting us, and we're adding beds to it. We don't want to overbuild again because we wind up with unutilized beds. So if we can focus on the correct number so kids aren't staying in detention for any length of time. And one of the challenges we've got is that, as Senator Thurston says, in Broward County, and earlier Ms. Holt talked about Hillsborough being big, strong communities that support initiatives, is we're a statewide agency, and one of the reasons we were able to reduce the number of commitments is we focused on community services. And we have to, if the community services are there, then we can help these kids get the same kind of treatment services they might have gotten in residential, but do it within the community and work with the community partners to improve that situation. But some of the more rural areas, we struggle a little bit to try and find services in those areas. So in an ideal world for me, and I think the department would certainly appreciate those kinds of changes, to have the resources to make sure that everybody has the opportunity for probation and getting community-based services.
And from the stakeholder perspective, in Tallahassee, what are FPAA and FPDA priorities? What have they been? And where do you see potential for success moving forward as we gear up for the next legislative session?
Well, my president, Carrie Howard, is here, and I think she's going to set our priorities. But, we continue to be extraordinarily interested in juvenile reform. We continue to be interested in continuing the reform in the area of the death penalty. But I think if you asked us, if we had our wish list, what we really are trying to do is, at least as it relates to our children, is trying to keep them out of the juvenile justice system at almost all cost, except for those things that we all recognize, serious violent offenses. We all understand what we're talking about, but for everything else, we think that we can find alternatives to it as long as we have the right community services and community interventions. And the numbers now are low enough to where even a large circuit like Miami and Hillsborough County and Palm Beach and Jacksonville, the numbers are small enough now where you really do have to do more individualized assessments and interventions and not have a cookie cutter approach to life. You just cannot do that. And you also have to recognize that not all families are built strong, as many of us have, and they just don't have the education or the resources to do some of the things. And frankly, the understanding, they just don't understand how to find themselves and maneuver through the system. When you look at violations of probation or community control, for me, a violation of probation because you couldn't get to a place to go do your community service hours, that, we need to think about that. When you give a kid a list of 200 places to call, and you yourself, the public defender, calls, and 150 of them say, I don't want any children here doing community service. You cannot set up a system that is too hard to maneuver or too hard to manage, and you have to put in realistic expectations of kids. A kid recently was told by us, you have to write 1,000 words. It was well worth it to write the 1,000 words. We got a wonderful diversion, so it was well worth it. But the pain of reading the paper, and finally, and it finally dawned on me, this is his paper, not mine. And so what are you doing? But remorse was very important. We needed to convince the victim that this child was truly remorseful, and we were walking away from everything. But he didn't even have any idea how to express it. And so we have to really realize that there are true challenges that bring people into the juvenile justice system. And I think we have to slow down life. I think we do have to stop labeling people. I think we have to recognize that mental health is a true factor that exists in our community, and I think in our country at this point. Kids are talking about suicide at 8, 9, 10 years old. That's just unacceptable to me. And so we just really need to understand and slow down this system and, frankly, take care of the people in our community. that are not perhaps capable of taking care of themselves because they don't have the wherewithal, they don't have the ability. We're just going to have to do that. That gives us public safety. That gives us quality of life. And I think we all are entitled to that, but we all have to be a part of it.
You can be tough on crime and be compassionate. And when it comes to the juvenile justice system, you can't forget that the kids need to be held accountable for what they do. And accountability is sometimes not everybody doesn't agree on what accountability is, or how to achieve it, or how to make that impression upon these kids that have not fully developed into mature adults at this point in their life. I can't really say, what specific priorities of the FPAA will be, other than I can tell you that all the 20 state attorneys are committed to listening and being flexible and being partners with the public defenders, with DJJ, with the judiciary, with all of the folks that provide services, because not one of my colleagues in each of the 20 circuits wants to ruin a kid's life. But at the same time, we've got a job to do, folks, and that is to make sure when you go home at night, that you and your family and your neighbors and your fellow citizens are safe. And so we are trying to strike a balance between therapy and accountability. And all I ask is that you realize that when you look at what we do and you start making judgments in individual cases, when you truly don't have any clue about what all the facts and circumstances are that might play into that. So we'll be patient, we'll be flexible, and we'll be honest and genuine with you, and we ask the same in return. Thank you.
So what I've heard from our panelists is that it is our responsibility as stakeholders in the system to develop and be involved in and implement a system that provides accountability with compassion. And as takeaways from this particular panel, I see a couple different opportunities for continued conversation. Number one, the conversation around individualized determinations and having a system that allows discretion for our prosecutors and discretion for our judges to work with other stakeholders in the system to provide that individualized response. What does this child need? The child standing in front of me right now with their educational experience, their mental health issues that run the gamut. What interventions does this particular person need, rather than having, as Ms. Holt said, a cookie cutter response that takes the discretion away from our decision makers in the system. We've also, I think, talked about more consistent implementation of appropriate civil citation programs on a statewide basis, because what we've seen from the numbers is with 4% recidivism rates from civil citations, those programs are working. And so conversations continued statewide among jurisdictions, and as we've seen even from county to county within our circuits, to have a more focused, more expansive civil citation program that allows for those case-by-case, as Mr. Larizza said, individualized determinations about whether a child is appropriate for a diversion-style program, and if the program is being denied, to be looking behind that, figuring out why, and if that was a decision made by the child, making sure that the child and his or her family have all of the information about what the program actually entails and the long-term effects. And then finally, I think a big takeaway for this group is the continued communication and collaboration, collaboration and communication among agencies and stakeholders in our communities, and also with the juveniles and the families that are involved in our systems, beginning from first touch of the system, whether first touch of the system is foster care, whether first touch of the system is a civil citation, or whether first touch of the system is a juvenile arrest, and coming into our juvenile delinquency system. I'd invite, we have a few minutes, if anyone in the audience has any additional takeaways or thoughts that you'd like to add. Yes, ma'am?
Yes, I have a takeaway. I run a pro bono attorney program in Hillsborough County, and I have for several years, and we represent children in foster care as their attorneys in dependency. And and then serve as attorneys at Lyden for them on the delinquency side, assisting the defense attorney. And also, unfortunately, we are often in criminal court as attorneys at Lyden providing mitigation. So my takeaway, I hope, is here. We can't be penny wise and pound foolish with children in Florida or anywhere, because they're not going to be successful. If we continue to have, as we do in Hillsborough County, where one case manager is overseeing the lives of 30 children, it's not going to happen. It's not going to happen well. And these children end up angry. They come in distrustful. They stay that way. We know, studies show that children who are in foster care are more likely to pick up delinquency charges and go on to serve time in jail. Now, I've seen the whole thing. Dependency, delinquency, and I still see, I have two children, well, one's a child, one's 18 now, who are direct filed and are in Hillsborough County Jail. Okay, all money issues. Money issue with regard to dependency, money issue when they're waiting for a placement in a commitment program in the detention center, and not getting any services, really. So, what's the point? And then money issue when they're direct file, when they're in jail for a very long time, because it takes a long time for a criminal adult case to move through. And they're not getting a decent school education. They go in, they probably had an IEP. They're not having IEP level education. They need English as a second language. They're not getting special treatment for that. Many of them have mental health issues. I know in the Hillsborough jail system, there's adult mental health unit, but there's not a juvenile one. Why, I asked? Money.
So what's your name?
Rosemary Armstrong.
So I think that Ms. Armstrong has just volunteered to be the leader of a stakeholder committee on legislative initiatives for funding for juvenile services, as to come out as a takeaway from this meeting. I think we can all agree that money is certainly an issue that as stakeholders we see across systems. Is there anyone? Yes.
As far as the civil citation dashboard, and this one that you've got up here showing right now, which has djj.state.fl.us/research/reports/interactive data report. Could you please just put a button on the website?
It's there.
You gotta dig down into the website to get the civil citation.
I'll talk to our data people. If you go to the first one, and it'll eventually you can get to it, but I'll see if we can do it.
You just do it with one click, or you gotta go through the search to find.
Not the technology guy.
So I would like to personally extend my thanks to our amazing panel of stakeholders here who have shared some really great thoughts on where we can move forward collaboratively. If you would like to join us for our Kumbaya session of how stakeholders across the board can come together to work on initiatives that we can all agree are going to influence in a positive way our public safety, our communities, and the children that we come into contact with through the system, you can meet us over in the lunchroom. We'll be there. Thank you all so much for joining us.